Good evening, ladies and gentlemen, and welcome to North Shore Live, Cooper's Corner. We're live this evening, and this is September the 11th, 2013. We'd like to extend our heartfelt sympathies to all those who have lost in the 9/11 disaster. Please allow us to, that's why I'm wearing red, white, and blue for this evening. We are America, we are strong, and we will stay strong. And we need to let our people know that we are Americans and that nothing can dissuade us. We have the flag here, and we have my saying is God bless America, and that's what we're all about. So fancy that this evening, which is September the 11th, 2013, is exactly 12 years after the devastation, but we are going to be having more conversation regarding Melissa Calusinski and her case here in Lake County. A 22-year-old at that time that was charged with an offense that attorneys believe could not have happened, and people are looking for a scapegoat. This young girl now has served 4 years in jail. She's all of 26, and a sentence was handed down for 33 years in jail.
31.
Or 31 years, thank you. And so we would like to talk further on this case, and that's what we're going to do. I should also like you to know that after we played the last program, and I publicly invited the state's attorney to be on the program, I didn't hear a word. Nothing was said. And but again, I heartily publicly invite Mr. What is his name? Nerheim, yes. Mr. Nerheim, the state's attorney of Lake County, to be on the program, and he doesn't necessarily have to talk about this case. It's just his procedure we would like to talk about. And again, Mr. Nerheim, you are more than welcome to come on this program. At any time, we will make it convenient for you. You just pick up the phone and call, and we'll have the studio available for your timeline. Okay, so without any further ado, my guests this evening, as you saw the front page, are Paul DeLuca, who is directly to my left, who is a criminal defense attorney, and to Paul's direct left is Dan Cummings, also a criminal defense attorney. Gentlemen, welcome to the program.
Good evening.
And it's a pleasure to have you here.
Thank you for having us.
Oh, listen, my heart throbs with this excitement because everybody else is just talking about the heat, which we have and had, but we need to talk about some other very dangerous situations besides the heat, which you or I can hydrate ourselves, but an unfortunate person is in the lockup and she can do nothing for herself in there. Paul, you take it away. Let's talk about the case and information and her confession and everything that went with it.
Bev, the case started actually in October of 2008. Benjamin Kingan at that time was approximately a little over a year old. He sustained an injury at the daycare center where Melissa ultimately came to work. In October of 2008, Melissa did not work there. She eventually got hired on. Benjamin, we learned, and everyone knew at the daycare center, it was common knowledge, Benjamin had a habit of sitting himself Indian style on the floor, and he would throw himself back at times pretty forcefully to the point where he would hit his head, and it would happen time and time again. The reports that we had involving this October incident was that somehow there was a a large lump on the back of his head. A few days later, he was taken to the doctor. I think it was part of a wellness visit because he had a temperature. The doctor did not perform a CAT scan or x-ray and felt everything was okay. Now we flash forward a little bit to January, mid-January, when Melissa's working there, and Melissa was one of several daycare workers that worked with Ben. She got along very well with the kids. Melissa has no history of any kind of violence whatsoever, of course. And again, the daycare workers that were working with Ben related to us and to the police how Ben would, even during that time period in January, continue to hit his head back at various times. Wednesday is the day that Benjamin died. I don't know I can't recall if it was the 14th then. I think it was perhaps the 14th of January. 15th, but it was a Wednesday. On Monday, I think this was pretty significant. The child began throwing up extremely, several times the child threw up just before his mother came to pick him up.
In a projectile
fashion. Throwing up projectile. One of their witnesses said she's never seen anything like this. They held him over the sink and he was throwing up. It's consistent, it's important, significant, because that's consistent with somebody suffering from a head injury. The child was also lethargic. We found out from other witnesses that Benjamin, throughout the day before the Wednesday that this happened, would roll his eyes, never quite took a good nap, was lethargic when the other kids were up, would roll his eyes at times, all symptoms, signs and symptoms of possible head trauma. Now on 14th, Melissa is working, Nancy Callinger is working, along with some of the other daycare workers. About 12 o'clock, I think, the child threw himself back, and then later on in the afternoon, shortly before he went into this cardiac arrest that ultimately led to his death, he threw himself back and hit his head on the tile pretty significantly, from what Ms. Callinger talked about. At the time this happened, Melissa wasn't even in the room. And then, of course, after that, he goes unconscious. The paramedics come, the fire department come, the police come, and everybody begins to get questioned. Logically, I suppose the police focus on Melissa and Nancy, the last two people with Benjamin prior to the time that he collapsed while he was in this chair, a little bouncy chair. What the detectives do not tell the coroner was the incident on Monday. The coroner at the time, Dr. Choi, when he does the autopsy on Thursday, does not know anything about the prior injury in October, does not know anything about Monday when the child threw up, and does not know anything about the head banging. No, the police knew about that. None of that was related to Dr. Choi. We thought that was significant. So Thursday, everybody's questioned at the daycare center, generally by the police, as you can expect. Come Friday, the plan is we're going to pull certain people out. And those certain people were Melissa, Melissa's sister, and one of the other daycare workers, and Nancy Callinger. So I think it was the four people were basically pulled out. Those were the main people pulled from the daycare center. I think Nancy might have come later on to the station. At the time they take Melissa, Crystal, her older sister, who worked at the daycare center, specifically asked for a phone call. That was denied. You can't make a phone call. She wanted to call her father and find out what's going on. My sister's being taken away. And what they did is isolate everybody. Melissa's taken to one spot, Crystal's taken to another station, Nancy's taken to another station, and then the process of interrogation begins. And Melissa was never made a phone call. Crystal asked to make a phone call, was never allowed to make a phone call until after, this is about 9 in the morning, I think statements ultimately were made by Melissa implicating herself around 5 o'clock or so. She's questioned by two seasoned detectives from the Major Crimes Task Force. And Dan and our belief, and Dan will go into it more too, that they forced her, they coerced her mentally, they played games with her, they led her to believe that there was only one way the child could have died, and ultimately they told her, if you tell us it happened this way, you're going home.
That's right, you can go home.
At the end of the tape, you'll see it's not in dispute. She says to the detectives, I can't wait to go home and pet my puppy. Would you guys start my car? It's been really, it was a very cold day. Would you guys start my car? It's been sitting all day. I can't wait to go home. There was, of course, no response. In her mind, she was going home because she relayed what they wanted, which, again, is our belief, and is a false confession, what we believe it to be.
Well, we had on the program the information. Number one is that she was 22 years of age at the time, and she suffers from a diminished capacity. So even if they read her rights, would she have understood that? Could she secure an attorney and not say anything further?
Well, the interesting thing about the rights, Melissa's a very, and we spoke to, I think, one of the individuals that knew her very well from high school. In fact, he testified, one of her counselors. And the interesting thing he told us is he said, I always kind of kept my eye on Melissa. Maybe she wasn't one of the cool kids in school. I always kind of watched out for her. I thought something might happen to her. I was always worried about her. Melissa's a very gentle individual, very kind soul. She has a kind soul. I think she has a good heart. Never, ever been violent to anybody. And when you talk about the Miranda warnings, now here's a girl that goes into the police, and they read her the Miranda rights, yeah. And they also told her, though, it's no big deal. We do this to everybody. It's routine. They diminish the importance of Miranda.
Well, they also, as we explained last week, that the police have the right to lie about certain things.
They do have a right to lie about certain things.
So,
and they did in this
case. And they did. Clearly. And she believed them that she was going home. So the understanding is anyone of that capacity and stressed out from the situation and was just eager to go home would have said anything just to please the police officers so she could go home. Right. And that's where we are. So,
and here's what people have to understand, and I think oftentimes it's a little bit counterintuitive when we don't understand this. People confess to things they did not do. How do we know that? In probably 1/3 of the DNA exonerations throughout the country, where we know the person scientifically did not do the crime, we see in those cases what? A confession. Mm-hmm. So we know that those individuals confessed
to something they
didn't do.
That's correct.
Okay, so, and people, I think, don't understand that occurs because they say to themselves, well, I would never confess to something I didn't do. But as you said, Melissa, her verbal IQ score was 71. That is, 70 is basically when you begin to say the old term, someone is mentally diminished. And in this case, clearly she was. The police took advantage of her, and they knew they took advantage of her. I think they were pretty aware. This girl had never been arrested before, had never had any contact with the police. She's dealing with the most experienced detectives and investigators in Lake County, whose job it is, frankly, is to get statements from defendants. And you're dealing with a girl who she had no chance.
Was there a woman police officer or detective there with her or for her? And another question is, seeing, I mean, you could very well see, although I've never met her or seen anything, I don't even know what she looks like, I just read articles, her ability to, converse with somebody was probably not tippy-top. Right. They would have said, anybody normal, and I say normal because the cops are supposed to be above normal.
Bev, what happened is this, I think.
Why did they take advantage of her?
They were able to verbally push her around.
Oh.
They intimidated her. They yelled at her at various times. They laid out various scenarios involving her. And what happens in these cases as Dan said, the average juror, the average person says, oh, there's no way I wouldn't confess to killing my own child or this or that. And the reality is we know it happens. And it's happening about every other week in Cook County with these exonerations coming out of Cook County. What happens, though, is the individual is placed in a setting. And, for example, in this case, if you observe the videotape, she's put into a corner.
Saw it,
well, she's put into, I'll tell you what happens. She's put into a corner. And one of the Chief Falenko, large, not heavy, but a tall, large man is on one side.
Over 200 pounds.
Right.
Oh,
he's on one side, and another
Right.
detective is on the. She's cornered. First of all, it's a psychological ploy. Every confession, you'll see this. Every videotape confession, the individual is basically in the corner. And what happens, I think, mentally, you try to understand why, and the people ask, why would this happen? Because after a certain period of time, now imagine yourself in a room, first of all, alone. No phone, no this, no that. Imagine yourself over 7, 8, 9 hours, and it, this repeated questioning. And after a while, the individual says, as Melissa did, "I will say what you want. I have to get out of here." And it happens. And it's a question: is it psychologically? They break them down to a point. Yeah, some people maybe, can withstand it. Others can't. But the studies show that, the individuals like Melissa, they do. They can't take the pressure.
And in this case, what was interesting was the words that they're saying that she used as an admission or a confession or what have you, they initially came from the police. The police suggested things to her.
Nothing to do with
They told her, this is what occurred. Scientifically, this is what occurred. Did they know that occurred scientifically? No. They told her we had two medical witnesses or two medical observers.
This is where the lying comes in.
Right.
And they have the ability to do that. The law stands behind them to be able to do that.
To a point.
But to help, with another word, to coerce, a prospective criminal confess.
Right, well, we believe there was coercion here.
Well,
I mean, in this particular case,
it sounds like
in this particular case, these officers, again, I think you have to understand what Melissa's about. This is a girl that has never had any contact with the police. Her employment record, completely spotless. Not a college-educated girl, got through high school.
Hey,
okay?
The world is full of people that aren't
Absolutely.
necessarily college educated.
We also had evidence in this case. We put her through testing. She was what I would describe as a very quote-unquote suggestible person. In other words, you could suggest things to her and she would accede to them. She'd say, okay. We had a psychiatrist that testified. We tried to get this into evidence before the jury, but it was not allowed. That she was in the top 1% in terms of individuals in the country who had taken this test as far as suggestibility, meaning you could get her to say most things that you wanted her to say. And the police are experienced. They understand. They knew what they were dealing with here.
Here's a small example.
That's pathetic.
One of the detectives used the word, and I argued this at various points in the motions in the trial, but here's an example. One of the detectives used the word slam. We know you slammed the child, you slammed the child, you slammed the child. Well, guess what? When she's finally making her statement at the end, guess what she says? I slammed the child.
Well, that
slammed.
was a word.
She's using their words.
All the words. In other words, Bev, she denied having done anything to this child for hours after hours
and then
after
all of a sudden she uses their terminology.
Words. Right.
Their terminology.
And imagine somebody.
And their scenarios.
Imagine someone who's never been dealing with the police, never been in police custody. You take her phone, her purse, you take her entire
private possessions,
you deny her phone calls.
Yeah.
Okay. It was pretty bad. But again, these are techniques the police use. This is why you get false confessions, because of these types of techniques, and it was very unfortunate. It's very unfortunate. We also, in this case, we had an expert that we brought in a pretrial hearing who is an expert on false confessions, Dr. Richard Leo from San Francisco, who's written widely on this subject. And we asked the judge to permit us to put into evidence his testimony, which would have allowed the jury to understand, A, false confessions do exist, And these are the kinds of things you need to watch for. What's her IQ? Does she have diminished capacity? What kinds of questions were utilized? Where was she seated in the room? Was vulgarity used? These kinds of things. Well, unfortunately, we weren't allowed to put that evidence before the jury, so the jury really was left to use their common experiences to understand whether a confession was false. And I frankly don't think, to be honest with you, when I talk to my neighbors, my friends, people generally, again, as Paul said, they don't believe people falsely confess. Well, we have expert witnesses who've studied this issue that could help the jury understand they do and how they do. We weren't allowed to put that in.
They don't understand it, and they don't believe it, they don't understand it. And the ironic thing is Illinois, which I believe has the most wrongful convictions. I could be wrong on that, but if we're not the most, we're up close. We're one of the jurisdictions that the law is very tough to allow false confessions into evidence.
We had 12 people on death row in Illinois who have been exonerated. What does that tell you? The system's failing us.
Something is very wrong. As I mentioned before, this was really no one's fault. The child himself created an unfortunate tragedy that you can't go back and fix. She was an innocent bystander that was there after the fact, and the police were looking at a collar, and the state's attorney is looking for votes. We're not looking for votes in this case, ladies and gentlemen. We're looking at a human being that has been harassed with that kind of a situation. I mean, I worked with a number of agencies, and the humane thing to do would be to get someone who the person is able to connect with, and certainly the fact that if she is disabled, diminished in any way, shape, or form, she should have had someone there to connect with. And the state's attorney certainly knows the Alliance for the Mentally Ill are there. If you pick up the phone, they should know, because I'm a part of that. For 35 years as a co-founder of the Alliance for the Mentally Ill, which is now NAMI, the National Alliance. And so we've seen a lot and we've heard a lot, and this is just pathetic. Mr. Nerheim, this is pathetic. Do you need the votes that badly that you have to crucify a 22-year-old girl to get your votes? That's a terrible thing. Again, I invite you publicly to come on the program.
Well, Bev, if I could just say something at this point. And I have asked, I've specifically asked Mr. Nerheim to review this case. We know he has a case review panel that was set up here. From what I've read, it sounded like a very good idea.
You can read that print if you like.
Well, I brought just to...
That's in print, and that's public knowledge now.
Yeah. I mean, my understanding is the committee, and I'm in favor of it. I thought it was a very good idea. And the panel is to review not only cases in which a defendant's guilt is called into question, it will also work to determine the causes of wrongful convictions and recommend policies. Well, you know, in our case, one of the reasons I asked them to look at it, because we question not only the confession, we question, you know, there's two parts of this case, the medical pathology part of it and the confession part. The medical testimony in this case has fallen apart. As you may know, or I think you know, we know there's the new coroner has re-examined this. Dr. Nancy Jones has looked at this. I believe Dr. Choi, the original pathologist, has reviewed it and has admitted he made a mistake.
Yeah.
Unfortunately, Mr. Nerheim has indicated that all of these matters have been hashed out in court, and it's not really, it's not an accurate statement. And I think a jury would definitely look at things differently if the state's own witness came in and said, oh, I made a mistake. This child did have a previous injury, and In fact, I believe that Dr. Choi's opinion now is very consistent with the defense experts we called in the case. So that was the reason I think...
Well, it's consistent with his head banging. I mean, and a comment that was made, I believe, that one of the detectives said was that he was dropped from a second-story window. Well, that's ridiculous.
That's a term, unfortunately, that is used, I think, wrongly in these types of cases. Pathologists, state's attorneys will throw that around. And in this case, let me tell you, there were no injuries to the child's neck. There were no injuries. Actually, part of Nancy Jones's report is that there were no blunt trauma where the state argued the fracture was. Dr. Jones is even questioning whether that was indeed a fracture or if it was a suture. Going back to, so this statement about it was consistent with throwing him out of a two-story window, and Dr. Choi backtracked on that when I cross-examined him about that. That's a statement made out of passion because a child is involved, I think.
As a mother of 7 children, I will tell you that when anything comes up about children or disabled children specifically, I'm on the spot. I'm right there, and we feel that they need assistance, and they don't need pejorative assistance. They need someone who is passionate about what their situation is because they can't fight for themselves. They need advocacy, and this girl needs advocacy.
Well, Bev, if you go back a little bit to these cases that are unraveling in Cook County and that have unraveled in Lake County and other counties, it's just as this is starting to. Something is wrong. We know something is wrong in this case because the medical testimony is come apart now with Dr. Choi's recantation. That's how it starts. And why do we have to wait 10 years before they finally agree, okay, we made a mistake?
And it's not just Dr. Choi.
It's not just Dr. Choi.
It's the coroner. It's another expert, that Dr. Jones. So we're in a different position now than we were at trial. At trial, it was a very emotionally charged case, obviously.
Believe me.
Very emotionally charged. And the state fought really hard to try to argue in the case that there was no prior injury. They argued it. They called Dr. Choi. Dr. Choi said no prior injury. We called witnesses to say, no, there's slides. There is evidence of prior injury. But now the state's own witness in the case, their key medical witness that they relied on, has now said, I made a mistake. I made an error. There was a prior injury, just like the defense said. And not only that, there's 2 additional people, the coroner and the other witness I mentioned, who now have come in.
Why is it that Dan, I'm sorry. Right, why is it that the judge refused to allow you to admit as evidence Melissa's psychiatric or anything thereabout?
Well, we were able to get in certain psychiatric evidence.
That would have been first and foremost on my mind.
The
jury was aware that she did have some diminished capacity, but because of that level that I talked about, under 70 IQ, on the verbal she was 71. The jury was aware of that. The problem in the case is, without the false confession expert, the 71 IQ doesn't mean that much to them. The false confession expert could have helped us and explained to the jury, really helped the jury understand in all the false confession cases that they've studied, and there's been many studies on this, one of the factors that you look to, which I think would be pretty obvious, as to who falsely confess, are people with low IQs. In other words, the fact, and that would have been something that the jury, so again, we might say that common sense would indicate that, yes, someone with a low IQ might falsely confess, but here would have been a nationally renowned expert on false confessions who could have explained that to the jury, who could have given somebody in the jury something to work with.
And we presented studies that were given to jurors, and jurors said, we want to know about false confessions.
Okay,
that will help us.
Sure.
But it was rejected, again, because the law is
Well,
ironically, very strict in Illinois.
But in this case, the judge did have the discretion. If he so chose, he could have allowed this witness to testify and educate the jury on the factors that lead to false confessions.
That's what I was just about to say. Is what problem would it have caused to educate your 12 jurors and let them know that there are such things as that?
His view was basically, and again, this is my recollection, expert witnesses usually are used in cases that the particular issue is beyond the common understanding of the juror. Well, he believed because the thing was on video, and whether somebody's telling the truth or not is something within the province of normal common understanding of the jury. But I think what Mr. DeLuca just said is we had a number of studies that indicated when you did simulations that jurors oftentimes got it wrong and didn't understand that there was false confessions because they don't know what to look for, right? Do you know what to look for?
No.
Really?
I mean, that's not my specialty. I don't know.
Right.
You know, I can tell you what to look for
so it wouldn't have
in front of the camera.
It wouldn't have done any harm. And I'm sure if we had been presenting our false confession expert, I'm quite sure the state probably would have hired their own. And at least there would have been two sides to it. But someone on the jury could have had a better understanding of what factors causes or contributes to false confessions. Unfortunately, we didn't have any of that in this case.
And she should have had an advocate there, an advocate from NAMI, the Alliance, National Alliance. Anyone with that type of capacity, diminished capacity, I mean, would have been the group, the advocacy group, would have been more than willing to show what has transpired, right, to be there on her behalf, to be there on behalf of justice. On justice, you're not taking his word or my word. You're taking justice, the side of justice. She is being falsely accused and falsely adjudicated for something that she did not have part or parcel in. And it's unfortunately, again, I must state, is that there are two separate identities. One is of a child who has a history of banging his head, and as Paul and I discussed before, about a situation about a child banging their head, and one of a school teacher, a preschool teacher, that's there to be able to administer to the children songs and music and coloring, and a totally non-violent person.
Bev, her account of what happened doesn't make sense, would never occur in the real world, and because her account is basically, she picked the child up and he was squirming, and she throws him down to the ground. Now, throws the child down, the child gets up, crawls over to the little bouncy chair, gets in the bouncy chair, grabs his little blankie or whatever it was he was grabbing. I mean, it wouldn't have happened. If she threw that child down, and Nancy Callinger was right next to her, the child would have stayed there.
Absolutely.
The child was 18 months old. Her own account doesn't even fit.
We should say some other things about what was going on at the daycare center. This was a busy daycare center. In other words, there was a number of children that were there. There were people that worked there, not just Nancy.
Girls, yeah.
There was probably, I think, 10 to 15 employees that worked there. People were constantly coming in and out of rooms. The room that Melissa allegedly threw the baby down had windows with adjacent children and where you could look in. It's preposterous that she would have thrown the baby down at that particular time with another coworker in the room, with people. And at this particular time, this was the end of the day. So other employees in the other room that was adjacent would be looking into Melissa's room and be motioning that the parents were there, or to bring these children into the next room. It's really absurd.
I also was told that the police chief, who's in charge of this squad, whatever this is, the
task force.
Yeah, the task force. It's an SS squad. That they took this baby, the decedent, and they brought him back to the scene of the situation, and they dropped him on his head, a deceased child.
No, that didn't happen. No.
Did that?
Let me say this. The Major Crimes Task Force, with all due respect, it's not an SS squad. It's a squad, and they're charged with very serious crimes, and but we think in this particular case, I can't speak to other cases, but I can say in this case, it was so emotionally charged with the child. I think they were convinced that was one of the two that had to have done it, and part of the reason they were convinced is because of the things Dr. Choi told them initially in his examination, which he now says is wrong. So remember, they're going out there thinking, Dr. Choi told us, oh my God, they threw
This
the baby.
thing, yeah,
That it's as if the baby was thrown from a two-story window.
Yeah.
They get tunnel vision. They get
That's
tunnel
right.
vision. They focus in on one particular individual. And again, I hesitate to want to say these are bad people, the police. I mean, they're trying to do the right thing. But what happens is they get so convinced in their own mind that this is the guilty person.
They have her all bundled up and ready to go off to jail. They're not even saying, wait a minute, maybe there is a flaw in the situation. What are we hearing from her?
They didn't listen to her when she told them what had happened.
Which is part of their technique.
They said it could not have happened the way you say it happened. Well, they were basing all of that. All of their thought processes about how it happened was what Dr. Choi told them in the autopsy, which we now know, A, he didn't have all the information about prior injuries. B, if he had had that information, the interrogation may have went differently. They had tunnel vision. It had to have been Melissa in their mind.
But you said before that they didn't speak with each other. One didn't know what the other one knew. Choi didn't know that the police didn't have that
the
knowledge.
police did not tell Choi all the facts. They didn't tell him about throwing out the prior injury or the headbang.
That also
might have made a difference.
That's a strike on the police. What they did,
Sure.
because they didn't confer with the preeminent physician who did the autopsy.
And now the slides. Here's what you have to talk
Come
about
back.
too. Now she's charged.
Okay.
2 weeks later, Dr. Choi decides, well, the slides took some time to prepare, I believe, but he looked at the slides. Histology slides are, as Dr. Lietzma, Dr. Jones, Dr. Larry Bloom, everyone we've conferred with, you have to look at, they call them histology slides, cuts of the brain, cuts of the various cuts of the pathology of, to look, and they know what to look for to determine if there's old blood, prior bleeding. I'm not an expert. I'm giving it to you very general. You have to look at these slides, though. We know that. Dr. Choi looks at them 2 weeks later. I think he sees certain things in there. He had some notations in his notes about iron. Iron is an indication of old bleeding, old blood. What's he to do, though? She's charged. I don't know what happened with Dr. Choi, but I think he was in a spot, and then, they had Dr. Montez, who doesn't look at any slides.
But you've got evidence that shows that there's something amiss here. You can't just be quiet about it. I would have jumped up and down. I would have run right to Neerheim's office and said, we have a problem here.
I would presume, or I would hope, that the State's Attorney's Office, the coroner's office is independent of the State's Attorney's Office. They should be. But we know from Dr. Montez's testimony that he apparently, he looked at the body the next day or the day of, made some observations, did some things in the case, and was told by the deputy coroner, Paul Foreman, not to make a report, don't take photos, not to, and don't take notes, and as if it was a secret. And to me, that was extremely disturbing.
I think the assumption is that this would all just go away. The judge would get his criminal, his criminal order together. Everybody tried this case before it was really tried. I mean, it's so obvious from the sounding. And when the reporter was here, Ruth was here last 2 weeks ago. She followed this case minute by minute, second by second, And it was just...
The child cases are extremely, they're extremely difficult cases. There's
with such passion.
So much passion.
And she said,
so
well,
much
I have
emotion.
to say something for Mr. Nierheim. I said, well, I do too. I know he wants to do his job, and we're all for that. Let him do his job. But, you know, let him do his job correctly. If there's new evidence that's come about, that needs to be brought to the attention of the court immediately. Yes. And if the tables were turned or the shoe was on the other foot, and this was Mr. Nierheim's daughter, do you think he would just let her sit in jail for 33 years or 31 years or whatever, if there's new information brought forward?
And there is new information, and I also want to credit Dr. Choi. I think showed a lot of courage.
I think as well.
A lot of courage.
Absolutely.
He agreed to take a second look at this thing. He re-examined it. He acknowledged his mistakes. You know, I think it's pretty clear in our system. It's not always very easy for those who make mistakes to acknowledge them. Well, so I appreciate, and you know, Mr. DeLuca does too.
There's a big ego trip for everybody. Lawyers, doctors, judges. Boy, you can't put your arms around the ego.
What?
The point is that if there is a mistake that's made and a person's life is in jeopardy, and she's young, my God, what is she going?
The difficulty with the difficulty with the panel. I think the difficulty in Cook County, although they are, you know, they are making progress in Cook, but it's taken a long time. But the difficulty is, in my opinion, Mr. Nierheim, to do this, to open an investigation, has to implicitly or impliedly say to the police, something you did here was wrong.
Absolutely.
You may have caused a false confession, and that's a difficult thing for the prosecutor to do to the Major Crime Task Force.
It might be difficult for him, but it's the right thing to do. There's a right and a wrong. There's no middle of the road.
Bev, I agree with you, but what I'm saying is that's what I think the problem is.
But when you've got someone in jail who is wrongfully there, and there was information that was not passed between one to the other, there needs something to be looked at. And the police, of course, hey, the ball is in their court. They've had it.
At this point, I don't see how this case doesn't fit the qualifications or the whatever the
stipulations.
The purpose of this unit is. I don't see how it doesn't fit it and why it can't be looked at.
Wrongfully, absolutely.
The prosecutor's role. We're all, you know, we're not all prosecutors, but we're all bound by the rules, the attorney registration, Supreme Court rules. Their role is to seek justice. That's in the professional rules of conduct.
Well,
we're governed by rules. They're governed by rules.
The ARDC should have gotten letters regarding this situation, that there is new information. The state's attorney of Lake County is refusing to acknowledge that there is new information, and he doesn't want to go forward. Well, you know, gentlemen and ladies out there, we're not talking about votes. We're talking about someone's life. You know, it's a life situation. It's a life of a young girl and the passing of an infant child. Neither of them had anything to do with the other one. It was two separate entities that happened climatically. I don't know what else you could say. It's incredible that these things happen, but they do, and they're not attached to each other.
There are a lot of mistakes made in baby cases. In fact, I would recommend to your viewers, if they're interested, there's an excellent piece on Frontline on the PBS website. You can look at it called The Baby Cases, where they basically examine for an hour exonerations that have occurred in these cases, problems with autopsies that have occurred in these cases. All throughout the country, there's a number of exonerations with these baby deaths because it's a really difficult thing for coroners to pinpoint sometimes what the cause of death is.
Well, I know that the state's attorney is doing his job as a state's attorney, and he didn't just walk into the position. He had to be voted into office. This bothers me in the most unbelievable way. This just sticks in my throat, is that we're not really looking. We on this program are looking at the situation can I have the camera here, please? We are looking at this situation as a human life, and unfortunately, from what it sounds like, I may be wrong, I'm not infallible, but what it sounds like is Mr. Nerheim does not want to go over this case because he knows there is new evidence, and this would exonerate for sure Melissa. So this is a situation. It's right and wrong, and a life as opposed to votes and getting into office. Mr. Nerheim, how big a person you would be, and that the voters would see you in that fashion if you went before the cameras or went into the court and said, we made a mistake. That's why they have erasers on pencils. We made a mistake. This girl has served 4 years in jail. What must she have gone through? You said she was questioned for 7 hours or 10 hours.
She's gone through hell, Beth. She's gone through hell.
What must she have gone through? Something has to be done.
But let me tell you this: she's going to survive this. You know, we believe in her, and I think she believes she's going to come back. You know, I believe the case is ultimately going to come back at some point. But it's just, I just can't understand the stubbornness, I guess.
Well,
the same stubbornness that we saw with Mr. Waller with some of these other cases. It's the same stubbornness. What's the harm? And this is one of my questions I posed to Mr. Nerheim. What's the harm of having somebody look at this? And I suggested before Nancy Jones got involved, go anywhere. Let's get a board certified.
She's a doctor, Nancy Jones.
But I said let's get an independent board certified pathologist. Look at these slides, because your people did not really. Dr. Montez did not look at them. Their other pathologist, Birnbaum?
Dr. Greenbaum.
Greenbaum did not look at them, and Dr. Choi made a mistake. Let's have somebody look at them.
But now, before you wrote that letter, now this information is available.
And now it's
Things
available.
have changed.
Things have changed.
We have Dr. Jones's report. We have Dr. Choi's courageous admission of
Very
a mistake.
good.
So it's different
Good man.
now. It's different now.
I don't understand it. Why not?
Well,
Why not look at it?
I'm telling you, we're talking about votes, and that bothers me. He sees her innocence, yet he's holding on to his votes. Well, people would vote for someone who is courageous, Mr. Nerheim, to be able to say, I'm sorry, I made a mistake, and go forward and correct the wrong that was done to this poor girl. Correct it. Correct it. That's what we're looking for. Correct the wrong that was perpetrated against a 71% tile, diminished capacity. I'm so upset about this. I would have been in court had anybody called me. I would have called everybody from the Alliance for the Mentally Ill. And it doesn't necessarily mean you have to be mentally ill. It's with any kind of mental discrepancy or any kind of mental situation, or call Equipped for Equality, or call all of these agencies that are part and parcel. I mean, the jail took a group of us from the behavioral health. I sit on the advisory board of Lake County behavioral health situation, and took us through the jail, and they said if anybody comes in here having any kind of mental problems, we will call any of you. I said, put my number down, 24/7. You can call me anytime. I'll be there. I'll advocate for whoever you've got there. If they've got a mental disability, you make sure you give me the information and the pills or whatever, and I will be there to advocate. These people have a right. This is the right. Even Public Law 94-142, federal law, says you have to educate someone to the age of 22. You cannot discriminate because they have diminished capacity.
Right, and I think that's the important thing. We're not saying she had a mental illness diagnosis per se. But what we're saying is
they took advantage.
Yes,
it bothers me.
Yes, her verbal ability, her verbal acuity was diminished, almost to the point what we talked about before.
Well,
and not only that, again, you talk about having. I think what you were talking about is having an advocate in the jail for her.
Someone should have been called, and that's what they brought.
Well, here's the problem. They wouldn't let her make a call to her father or to anybody. What she should have had in there was a lawyer in the police department who could have advocated for her and protected her. But when you again, if you read someone their rights, but you don't allow them to make a phone call, and if you take if you take her cell phone, which they did, and if you also take her sister's cell phone, because her sister was
there was no reason to take Crystal down to the station.
Right.
She was not even involved.
Part of this.
They knew that she was going to call her father,
right,
who then would have called a lawyer, who would have then gone down to the station and protected her.
And
she had no one to protect her down there, and she was not capable on her own of dealing with these experienced, veteran, knowledgeable detectives.
With the ADA, and that's the Americans with Disability Act, everything is there for the disabled person, verbally disabled, whatever disability. She has that right. I mean, this is America. This is America. You know, God bless America. What is happening? Is this job so lucrative that the prosecuting disposition of Lake County can't wait to get these people in jail because it's money, it's in some way, shape, or form, either money or favors or something? I don't understand. Something is very wrong here. Innocent people, when they say, oh yeah, everybody in jail says they're innocent. Well, you know, now you got to take a second look at that. And maybe these people with acuity of, 50% or 60% have the right, were hoodwinked into saying what they wanted to, and either some attorney or some judge got his boost being a judge because he put someone with that diminished capacity in jail, and he's got a star in his column because he did good for the community. I think if the community was as distressed as I am right now, up in arms, we would go down to that courtroom and fill it to a man to make sure that justice is being served. Justice is blind, but not stupid. And so, therefore, take off the blindfold, look at the damn slide, and make a decision. And if that's new information, this should have happened. This case should never have happened.
And here's the thing. We have an epidemic, really, of false confessions that we're seeing here, across the country. Let the false confession expert talk to the jury.
Let them, absolutely.
About what his findings are.
Educate the public.
Yes.
That's what this program is all about, Dan.
Right.
We educate the public on what's going on. We could have a knitting corner, a sewing corner, a book corner. This is all important. People like to hear about that. But I'm for those who are discriminated against. And I spoke before the legislature. I mean, you're not talking to someone who hasn't had some, hands-on here. And in Springfield, and you could have heard a pin drop what I was speaking on behalf of. Those who had no voice because they didn't know how to speak. There was no one there to protect them.
Every murder case now has to be videotaped. Pretty soon there's going to be a law that serious felonies have to be videotaped. Why not let the false confession expert? I mean, I think it should be a legislative. I think it should be a legislative action.
We're making some incremental progress, but we see even with this incremental progress, we're still seeing false confessions.
Well,
you see it every other week now.
I need to let you know that this is a little sidebar, little law here, that we had difficulty in Cook County in the probate court, and for 7 years was the victim of a judge, Lynn Kawamoto, the only Asian on the bench in probate, only Asian. And for 7 years, I mean, I was guardian, I was power of attorney, and she removed me and put my mentally ill daughter, documentation, my mentally ill daughter as guardian. Took advantage of a situation. Anyhow, the long and the short of it is, she gave all of my mother's estate and finances away. My mother has passed away 2 years now. She was 99. In good health. All she had was arthritis. 99 years old. And she passed away 2 years. The GAL, the guardian ad litem, Mr. David Martin, has been paid for 2 years since my mother's passing. Is he communing with her spirit? But they wouldn't give us money to pay for her burial.
Well, let me say this, Ben.
And wait, one more thing, I'm almost finished.
Yeah.
And the fact is this judge now has, she's no longer on the scene. She was removed. So Judge Lynn Kawamoto is no longer on the 18th floor. And we brought this to you time after time after time on this program. So good luck in Texas, Judge Kawamoto, and I hope that the press follows you. And as far as this case goes...
Well, let me say this.
Okay.
We believe in the judicial system.
Oh, that's all we've got.
And we would like Mr. Nerheim to review this. Maybe he'll change his mind. In the meantime, you know, I believe in the appellate court. I believe in perhaps going back. You know, something is this case, I believe, is going to come back somehow,
yes,
some way, for either a new trial or a dismissal. At some point.
Yeah.
At the least a new trial. I don't see how you can't have a new trial, how the appellate court cannot grant a new trial based upon Dr. Choi's
Dr. Choi's
affidavit.
Revelation now is relatively new. So this is a new opportunity for Mr. Nerheim to potentially take a look at what Choi has said and what Jones has said, and we're asking that he do that prior to the appellate process being completed. There can be a second track here. We're asking him to have his group review this thing.
That's all we're looking for.
Right.
That's all we're looking for. We've got about 2 minutes left. Either you gentlemen would like to make any kind of closing statement here? Not an argument, but...
Well, I wanted to address one thing.
Sure.
There cannot be a worse thing when you're in jail and you're innocent. Paul and I have been down to the penitentiary, and you asked before what Melissa has gone through. It's really awful. I mean, it's terrible to see her down there.
Terrible to be there.
Right. Right.
Take it from one who's been there. I know that situation.
So it's awful.
See,
it's
I
horrible.
have a lot of experience here.
It's been an excruciating scenario for the parents.
Yeah, for sure.
I mean, it's awful for her sister to know that their daughter is innocent, but nonetheless wrongly convicted.
Wrongly convicted. Well, Paul, what have you got to say on that?
Well, you know, I think justice will triumph. I think it's going to be sooner than later, and I think, you know, again, my request would be for Mr. Nerheim, assuming he's watching, to look at the evidence. It's the right thing to do here. Look at the new evidence.
I hope that it is. Mr. Nerheim, we're all for you. You are our state's attorney in Lake County, and if you see a wrong, you must correct it. That is ethically correct. You must correct it. We hope that you will, and the voters hope that you will as well. Have a pleasant evening, a very safe week. Stay hydrated. Weather changing, be very careful. And all I can say is our greatest heartfelt condolences to those who've lost loved ones from 9/11. God be with you. See you next week on North Shore Live, Cooper's Corner. Have a good evening.